This is the brief on Philippine crimes against religious worship. The Philippine Revised Penal Code draws a fascinating, highly specific legal line between being a church nuisance and committing an actual crime against religious beliefs. First, in a classic 1913 case, a guy barged into a Methodist home Bible reading, literally threatening the congregation with a club. Now, is every violent church disruption a religious crime? It's the legal equivalent of the difference between a standard public disturbance and a targeted hate crime. The Supreme Court ruled it a mere public order misdemeanor, because without proof of intent to coercively force or alter worshippers' beliefs, it simply wasn't a crime against religion. Second, the act must meet a strict definition. Take a crazy 1934 case where men maliciously built a barbed wire fence outside a chapel during a pabasa, a Catholic Holy Week ritual reading of Christ's Passion. When the panicked crowd fled, you'd naturally think ruining a holy event is a religious offense, right? Legally, no. An act must actively ridicule a dogma or ritual. The court downgraded their crime to mere unjust vexation, essentially severe public annoyance. Finally, apply the subjective standard. In 1939, a Church of Christ funeral was forcefully marched through a Roman Catholic churchyard against the priest's wishes. So, when it comes to the law, who actually gets to decide what's notoriously offensive? The Supreme Court ruled religious offense is entirely subjective. It's judged strictly from the viewpoint of the complaining faithful, not an objective outsider. Ultimately, Philippine law dictates that a true crime against religion requires either a coercive attack on personal belief or a direct, subjective insult to the faithful's dogmas. Everything else is just bad behavior.
Welcome to this video on faith, freedom, and the law, where we decode crimes against religious worship in Philippine jurisprudence. We begin with the historical paradigm shift of 1898. Pre-1898, the focus was the absolute protection of the state religion. Post-1898, the Philippine Bill established a complete separation of church and state, ensuring equal legal protection for all religious denominations. Section 4 of the Revised Penal Code covers crimes against religious worship. Article 132, interruption of worship, is committed by a public officer who prevents or disturbs religious ceremonies. Article 133, offending religious feelings, is committed by anyone performing notoriously offensive acts during a ceremony or in a place of worship. Article 132 requires strict adherence to its elements, a public officer disrupting a ceremony. The location dictates the offense. A disruption in a public plaza may be a different offense, but disrupting a religious service in a private home is a protected ceremony under Article 132. The 1913 case U.S. v. Balcorda stress-tested the law. The service in a private home was interrupted by a man threatening worshippers. The verdict was coercion and public disturbance, but not a religious crime. The rationale was the absence of intent to coercively control religious beliefs. Article 133, offending religious feelings, has contextual triggers. Path A requires violating the sanctity of a space devoted to worship. Path B requires violating the sanctity of an active religious ceremony. Critically, both paths require a deliberate intent to hurt the feelings of the faithful. People v. Reyes, 1934, illustrates collateral damage. A rival family built a barbed wire fence outside a chapel during a religious reading. The intrusion caused a panic and abandoned the ceremony. The court in Reyes drew a line between vexation and profanation. The defendants were acquitted of Article 133. The act lacked a deliberate intent to mock religious dogma. Building the fence was an aggressive property dispute, which was ruled as unjust vexation. The clashing of rights in People v. Bays, 1939, involved a funeral procession being forced through a Catholic churchyard. The initial dismissal was reversed by the Supreme Court, identifying a constitutional issue regarding whose feelings dictate the offense. This led to the complainant's view doctrine. Whether an act is, quote, notoriously offensive, is a question of fact, judged only by the feelings of the specific congregation involved. In Baez, the offense was viewed through the lens of the Roman Catholics whose churchyard was violated. The synthesis reveals that disruption alone is never enough for a religious crime. The state requires a clear intent against the religion itself, specifically the intent to control or ridicule dogma, as seen in the Baez case. The enduring principles of architectural justice are absolute equality of faith, strict statutory boundaries, and the subjectivity of offense. These principles ensure that all sects are protected, and that only deliberate acts of profanation are judged as religious crimes.
All right, let's dive right in. We're going to travel back in time for this one, all the way to the 1930s in the Philippines, to untangle a really fascinating legal puzzle. It's a story about faith, the law, and what happens when those two things collide in some very unexpected ways.
So, at the center of this whole thing are two totally real incidents. Picture this. On one side, you've got these guys who show up late at night during a Holy Week service, and they're armed with crowbars and tools and start building a barbed wire fence right in front of the chapel, throwing the whole ceremony into total chaos. Then, on the other hand, get this, a funeral procession for a member of one church is literally forced through the private churchyard of a rival Catholic church, using threats to push their way past the priest. So here's the puzzle for you. Looking at these two situations, which one do you think the courts decided was actually a crime against religion? Was it the guys building the fence, or the group that crashed the churchyard? The answer? Well, it's probably not what you're thinking.
Okay, so to even begin to solve this puzzle, we have to get into the nitty-gritty of the law. We're going to break down Article 133 of the Philippine Revised Penal Code. This is the law that deals with this very specific crime of offending the religious feelings.
So the whole law really hinges on this one very specific and honestly kind of vague phrase. An act becomes a crime against religion if it is notoriously offensive to the feelings of the faithful. Now, what in the world does notoriously offensive even mean, right? Well, that is where it all gets really interesting.
Okay, so the law basically gives us a two-part test. First, whatever happened has to be super offensive, like in a public, scandalous way, to the people who believe in that faith. And second, it has to happen either in a place of worship, like a church, or smack dab in the middle of a religious ceremony. Now, both of our cases seem to check that second box, so it really all boils down to that first part. What was the nature of the offense?
And this, right here, is the absolute key. The law draws this incredibly fine line, a line that changes absolutely everything. See, it's not just about what these people did, it's about why they did it. Was their whole point to attack a religion, or was there something else going on?
And to understand this whole idea of intent, we can look back at some legal history. This quote actually comes from an even earlier case, U.S. versus Balcorda. Basically, the court laid it all out. For something to be a real crime against religion, you can't just be disruptive. That's not enough. You have to have the intent, the specific goal of messing with someone's religious beliefs. The target has to be the faith itself.
So this does a great job of laying out the two different crimes we're talking about. On one side, you have offending religious feelings. That's when your main goal is to mock a religion, to ridicule it. It's a straight-up attack on faith. But if your goal is just to annoy someone, to irritate them, to vex them, even if it happens at church, that's a totally different and lesser crime. It's called unjust vexation.
Okay, so now that we know all that, let's circle back to our first case. Remember the guys who built the fence during that Holy Week service? Let's see how the court used this whole intent thing to figure it out.
All right, so what do you think happened? I mean, they brought tools, they caused a huge scene, they stopped a sacred ceremony cold. So was their goal to attack the Catholic faith, or was there something else motivating them?
Well, the Supreme Court saw right through them. The fence builders tried to argue they were just, protecting their property. But the court basically said, yeah, right. They called it a pretense only. The court looked at the timing, the way they did it in the middle of the night, and decided it was all just a big show to annoy the people gathered there. Why? Because of some beef they had over land. So, here's the first part of the verdict. The fence builders were found not guilty of offending religious feelings. And the reason is simple. Their fight wasn't with the religion, it was with their neighbors.
But wait, they didn't just walk away. They were found guilty of unjust vexation. They intentionally and maliciously annoyed a bunch of people, which is still a crime. So the key takeaway here is their intent wasn't to desecrate a faith. It was just to settle a petty personal score.
Okay, so that's case number one. Now let's switch gears to our second case, the funeral procession. Because this is where the law takes another really fascinating turn and sets up a rule that people still argue about to this day.
Now, if you're following the logic from the fence builder case, you might be thinking, okay, this isn't a religious crime either. Maybe it's just trespassing or something. They wanted a shortcut, the priest said no. Simple. But that is not how the court saw it. Not at all.
So let's just do a quick recap of the facts so we're all on the same page. You have a funeral for someone from a totally different church, and it's deliberately, forcibly marched through a Catholic churchyard, a place the Catholics consider sacred ground, all while threatening the priest who's trying to stop them.
And this is the mic drop moment from the Supreme Court in the case People v. Bays. The court says, look, when you're trying to figure out if an act is offensive to a religion, you don't judge it from a neutral point of view. And you definitely don't judge it from the offender's point of view. No, the only way to judge it is according to the feelings of the believers themselves.
Wow, so this ruling basically created a huge new principle. For this specific law, offensiveness is in the eye of the believer. Since the Catholics in that town felt that forcing another church's funeral through their sacred ground was a major desecration, the court agreed with them. The act was labeled notoriously offensive, precisely because of how they felt, and boom, the people in the procession were found guilty of a crime against religion.
All right, so let's tie this all together. What are the big takeaways? First, Philippine law draws a really fine but super critical line between just being annoying and launching an actual attack on faith. Second, the key, the absolute game changer is intent. Was the goal to settle a score, or was it to ridicule a religion? And third, and this one is huge, whether an act is offensive isn't decided by some objective standard. It's judged from the perspective of the believers themselves.
And that leaves us with a really big question for today, doesn't it? I mean, these cases happened way back in the 1930s, but the ideas they bring up, they're more relevant now than ever. In our modern, super diverse world, with so many different beliefs all living together, how should we balance protecting one group's religious feelings against other fundamental rights, like freedom of speech or expression? That's a legal puzzle we are still trying to figure out.
Imagine you are sitting on a jury.
Okay.
Or, maybe you are the judge, right? And a case lands on your desk that demands you legally define if an act offended someone's faith.
Oh, wow. Yeah, that's a tough one.
Where do you even begin with that? I mean, think about the tools the legal system usually works with. We have property lines, we have timestamps.
Right. Forensic evidence, financial records, that sort of thing.
Exactly. Law is built on the tangible.
Yeah.
But faith, I mean, you can't take an x-ray of someone's religious feelings.
No, definitely not.
You can't put their soul on a scale and measure exactly how much it was damaged by a disruption. It is entirely invisible.
Yeah.
And intensely personal.
And frankly, a completely subjective.
Yes, completely subjective. And yet the justice system has to somehow deal with it. It has to draw a line in the sand.
Yeah.
So that is the puzzle we are solving for you today. Welcome to the deep dive.
It really is the ultimate collision of two completely incompatible worlds. On one side, you have the machinery of criminal law, which demands objective facts to justify taking away someone's liberty.
Right. You need hard proof.
Exactly. And on the other side, you have the realm of the sacred, which operates entirely on belief, emotion, and intangible dogma.
Right. Things you just can't measure.
Asking a secular court of law to step into that spiritual space and make a binding, objective ruling on whether a subjective feeling was offended, I mean, it's an incredibly dangerous tightrope walk.
It sounds like a total nightmare.
It is a jurisprudential nightmare, truly.
Okay, so let's unpack this. We have a fascinating stack of sources to guide us through this maze today.
We really do.
And we're not just looking at modern theory here.
Yeah.
We are digging into a collection of landmark Philippine Supreme Court decisions. And these span from 1913 all the way to 1939.
Yeah, really crucial era.
We've got the historical cases of U.S. versus Belcorta, People versus Reyes, and People versus Bays. Plus, we're reading these alongside some heavy-hitting legal commentaries on the Revised Penal Code, specifically Articles 132, 133, and 287. So our mission today is to figure out the exact mechanisms the justice system uses to measure, define, and protect the act of worship, all while keeping the government completely neutral.
What's fascinating here is that we aren't just looking at dry legal rulings.
No, not at all.
These documents are essentially a time capsule. They show a society going through a massive traumatic and foundational transition.
Oh, absolutely.
The Philippines, during this specific era, the early 1900s, was navigating a profound shift in its core values regarding the relationship between church and state.
Because things were changing rapidly.
Exactly. The judges writing these decisions weren't just passively applying established law, they were actively inventing what modern religious freedom actually looked like in practice day to day in a deeply religious society.
And to understand how the law protects your religious rights today, we really have to look at the historical blueprint hidden inside the oldest source in our stack.
Yes, the 1913 case.
Right, the 1913 case of U.S. versus Balcorda. Because before we talk about a level playing field, we have to talk about what the field looked like when it was heavily tilted.
The Balcorda decision is, well, it's essentially a masterclass in legal archaeology.
I love that term, legal archaeology.
It fits perfectly because to justify their 1913 ruling, the Supreme Court had to look backward to the Spanish colonial era. During those centuries of Spanish rule, the legal framework wasn't just friendly to the Catholic Church.
He was structurally fused with it.
Precisely, fused. But it wasn't a static relationship. If we look at the Spanish Constitution of 1869, it explicitly provided for a state religion.
Right, it picked a favorite.
It did. Now, it did allow for the private practice of other sects, subject to general law and morality. But the state threw all its weight behind one specific faith.
Okay, and it's interesting to see how the penal codes followed those constitutional shifts. Like under that 1869 Constitution, Spain promulgated a penal code in 1870.
Right, the 1870 code.
And the text notes something really curious. Because all restrictions upon the exercise of religious beliefs were supposedly removed by that 1869 Constitution. The 1870 Penal Code actually had a chapter on crimes relative to the free exercise of religion that was wholly impersonal.
Which means it didn't explicitly name the state religion as the sole victim of these crimes.
Like, really? It was neutral.
It just defined offenses against religion as a general concept. It was this brief moment of theoretical neutrality.
Wow.
But, it didn't last. The political wind shifted, and the Constitution of 1876 in Spain rolled back that neutrality.
Of course it did.
Yeah, it maintained the state religion. And while it guaranteed that no one would be molested for their religious opinions or private worship again, provided they respected Christian morals, it added a massive defining caveat.
Okay, what was the caveat?
Only the followers of the state religion could engage in public ceremonies or other manifestations.
Oh, wow. That is a huge distinction.
Yeah.
So the law essentially said, you can believe whatever you want in the privacy of your own living room, with the curtains drawn, but the public square, the streets, the plazas.
That belongs exclusively to the state religion.
Exactly.
Man. And that constitutional philosophy flowed directly into the penal code for the Philippine Islands, right? The one promulgated in 1884.
It absolutely did. Because of that 1876 restriction on public worship for non-state religions, the 1884 Penal Code reflected a deeply unequal playing field.
Yeah, the source material spells this out so clearly. Of the 8 articles defining and penalizing crimes against religion and worship, 6 referred specifically and solely to crimes against the state religion.
That is a heavily stacked deck.
Super stacked. The legal architecture was built to say, we protect this one specific institution from almost everything, and the rest of you get the bare minimum.
Right, and the sources point out there was only one crime specifically defined against religions other than the state religion.
Just one.
Just one, and that was for disturbing their ceremonies with violence or threats. But even then, there was a catch. There's always a catch. Yeah. What was it?
It only applied if those non-state ceremonies were conducted in cemeteries or lawfully authorized places.
Which, considering the public ban on non-state ceremonies we just talked about, meant those authorized places were very few and far between.
Exactly. That was the oppressive legal landscape. But then, at the turn of the century, a massive geopolitical and legal earthquake occurred.
The change of sovereignty.
Yes, the shift from Spain to the United States. With this American administration came the Philippine Bill, and specifically, the 14th paragraph of Section 5.
Okay, paragraph 14, what did it do?
This single paragraph enacted the absolute complete separation of church and state.
Wow, overnight.
Overnight. It abolished all special privileges and wiped out all restrictions that had been imposed upon any particular religious sect. The state religion was no longer the state religion.
I love trying to picture what the day after looked like for the judges on the ground.
It must have been chaotic.
Right, so it's like inheriting a massive, sprawling, ancient mansion that was custom built for one specific aristocratic family. The architecture, the vaulted ceilings, the exclusive staircases, the security system, everything was designed to cater exclusively to them.
I like this analogy.
And suddenly, a new government takes over and tells the local judges, hey, you have to rezone this building as a public community center by tomorrow.
Yeah, exactly.
You have to knock down the VIP rooms, you have to open the doors to everyone, but, and here's the catch, you cannot let the roof cave in. You have to figure out which walls are load-bearing and keep those.
That analogy captures the exact jurisprudential friction of the era.
It's wild to think about.
The Supreme Court in 1913 couldn't just throw the entire 1884 Penal Code in the trash. I mean, society would descend into anarchy.
Right, they still needed laws.
They had to sift through it line by line. As the court noted in Belcorta, all those articles of the Penal Code defining special crimes against the former state religion, as well as that one article defining a narrow crime against all others, necessarily became inoperative.
Because they were unconstitutional under the new regime.
Exactly. Only the laws that protected all religions equally, without distinction, could be kept alive. They had to find the load-bearing walls of religious liberty.
And according to the ruling, the court sifted through the rubble and found exactly 2 articles that survived this rezoning process.
Just 2, Article 223 and Article 571.
And the court spends a massive amount of ink analyzing Article 223, right?
They do. It penalized anyone who, by means of threats, violence, or other equivalent compulsion, forced someone to perform an act of worship or prevented them from performing such an act.
And we really have to ask ourselves why the court focused so heavily on that specific phrasing.
Well, the court explained that forcing someone to worship or preventing them from worshiping aren't 2 different crimes.
Wait, they aren't.
No, they are essentially 2 sides of the exact same coin of religious intolerance.
Oh, I see.
The underlying purpose of Article 223 wasn't just to stop public brawls, it was to protect the inner sanctum of the human mind, the will and conscience of the individual.
The court even points out a historical reality here. It is much more common for people to interfere with freedom by preventing someone from worshiping the way they want, rather than forcing them to adopt a new alien ceremony.
Yes, exactly.
But the legal injury is identical. If you stop someone from praying because you despise their creed, you are tampering with their conscience, just as much as if you held a weapon to their head and forced them to pray to your God.
Right. The law recognized that a person's religious freedom is violated when coercive methods are used to change their behavior based on religious intolerance.
Ah, so it's all about the motive.
Precisely. The law isn't just looking at the physical act of disruption like a shove or a shouted threat. It is forcing the prosecution to peer into the invisible motivation behind the disruption. It demands proof of the why.
So we have this newly established level playing field where all faiths are legally equal, and the state is suddenly blind to which God you pray to.
In theory, yes.
Yeah, in theory. But how does that actually work when real human beings with real prejudices collide in a living room?
That's where things get messy.
Let's look at the facts of the Belcorta case itself to see this brand new legal philosophy stress tested.
The facts of U.S. versus Belcorta are striking in their simplicity, yet they perfectly encapsulate the social friction of this transitional era.
Set the scene for us.
The setting is a private house. An individual named Buenaventura Belcorta, who belonged to the Aglapayan faith, which was a prominent independent Catholic church in the Philippines, enters this house uninvited.
Okay, so he's trespassing, basically.
Pretty much. And inside, between 10 and 20 people are gathered, conducting services of the Methodist Episcopal Church.
So we are talking about a small, intimate gathering, a house church.
Yes.
And Belcorta doesn't just walk in, sit in the back, and respectfully disagree with the theology. He threatens the assemblage with a club.
A literal club.
He uses the explicit threat of physical violence to interrupt and shut down their divine service. Now, the lower court looked at this physical intimidation and threw the book at him.
They absolutely did.
They sentenced him to over 3 years in prison under Article 223, that heavy-duty law we just talked about, against coercing someone's religious practice.
Because the lower court saw a religious service stopped by a man with a weapon and assumed religious coercion.
Makes sense on the surface.
Right. But the Supreme Court took a much more forensic look at both the nature of the gathering and the precise nature of Belcorta's intent.
Okay, let's break that down.
First, we have to look at the defense's argument regarding the gathering itself, because it goes right to the heart of what the state considers legitimate religion.
Oh, this is fascinating. What did they argue?
The defense argued that the people in the house weren't holding a proper religious service. Because the group was simply reading some verses out of the Bible in a private home, the defense claimed it didn't merit the full protection of the law against disturbing religious worship.
Which is essentially arguing, come on, Your Honor. It's just a dozen people reading a book in a living room. There's no altar, there's no stained glass, there are no vestments. That doesn't count as a real church.
That's exactly what they were saying. But the Supreme Court shut that elitist definition down completely.
Good for them.
They ruled that reading Bible verses in a private house absolutely is a religious service. They brought in a U.S. precedent, Hull versus State, which explicitly said it makes no difference that the method of worship of those assembled was singular or uncommon.
Wow. So the method doesn't matter at all.
Not at all. The protection extends to all, irrespective of creed, opinion, or mode of worship. As long as the gathering isn't indecent or unlawful, they have the absolute right to gather without being molested.
That ruling permanently cements the level playing field concept. The secular state officially divests itself of the power to define what a proper or orthodox service looks like. A cathedral and a living room have the exact same legal shield.
Exactly. But then, having established that the gathering was legally protected, the court had to evaluate Belcorda's actions.
Right. What crime did he actually commit?
Did he violate Article 223, the major felony against religious liberty? Or did he violate Article 571, which was merely a lesser misdemeanor for simply disturbing a ceremony or public order?
And this is where the court's earlier deep dive into the philosophy of Article 223 pays off, right?
Justice.
The court asks the critical question. What was Belcorda's internal motive? The record showed he was Aglapian and the congregation was Methodist. A religious clash seems obvious, right?
You'd think so.
But, and this is the massive turning point in the case, none of the witnesses stated that Belcorda made any comment whatsoever about religion during the attack.
Not a single word.
He didn't preach at them. He didn't hurl theological insults. He didn't demand they convert to his faith. He just threatened them with a stick to make them stop what they were doing.
The distinction actually hinges on the burden of proof regarding intent.
Okay, explain that.
The court reasoned that an essential non-negotiable element of the severe crime under Article 223 is the specific intent to coercively change, control, or insult the religious beliefs of another person.
And they couldn't prove that.
They couldn't, because the prosecution could not prove that religious hatred or intolerance prompted Belcorda to act because he didn't voice any religious objections while holding the club. The court refused to simply assume his motive was to tamper with their conscience.
Oh, wow.
Without that proof of intent, his offense was downgraded from a major, years-long felony against religious liberty to a simple misdemeanor disturbance against public order under Article 571.
Okay, wait. I have to push back on this a little bit because it feels like a legal loophole.
How so?
So if I barge into a local book club with a baseball bat because they are being too loud and annoying me, that's just a misdemeanor disturbance.
Right.
But if I barge into that exact same book club with the exact same bat, but I scream that I specifically want to force them to stop reading that specific book because I hate the author's ideas and want to control their reading habits, suddenly that's a massive felony.
Legally speaking, yes.
But the law is acting like a mind reader here. How is a prosecutor supposed to prove what's in a guy's head if he doesn't say it out loud?
Well, it's less of a mind reader and more of a behavioral archaeologist. The law forces the prosecution to dig up behavioral artifacts like what was shouted during the disruption, previous threats, documented animosity to prove intent.
Okay, I see.
The physical act is identical in both of your book club scenarios. You entered with a weapon and stopped the gathering through fear. But the justice system assigns a drastically different penalty based on the invisible motivation behind the physical act.
So they have to prove the why.
Exactly. The prosecution has to prove why you disrupted the gathering to apply the heaviest penalties. If they can't prove the why, they are legally restricted to only punishing the what.
It's a fascinating needle to thread. The court is bending over backwards to protect the house church as a valid, sacred gathering. But simultaneously, they are protecting the violent disruptor from the harshest religious coercion penalties unless the state can provide undeniable hard proof of religious bigotry.
That's the balance they struck.
So, Belcorta shows us that the law acts as a strict referee regarding intent. But what happens when the intent is incredibly obvious, undeniably disruptive, but completely secular?
Yes.
How does the law handle a situation where the disruption is massive, but the motive is real estate, not religion? That brings us to 1934, in a case that tests these boundaries in a wonderfully absurd way.
Let's examine People versus Reyes. If Belcorda was about deciphering the silent intent behind a threat, Reyes is about untangling the messy context of an interruption.
It's quite a story.
It is. The setting here is deeply cultural. We are in the barrio of Macolong, in the municipality of La Paz, province of Tarlac. It is Lent, and a local chapel is holding what is known as a pabasa.
Let's set the scene vividly for you because the text gives us incredible details.
Please do.
A pobasa is a continuous day and night gathering where people professing the Roman Catholic faith read from a book called the Vida, Pasión y Muerte de Jesucristo, which is a full account in verse of the life, passion, and death of Jesus Christ.
It's a very serious undertaking.
Yeah, they start on Palm Sunday and go nonstop, round the clock, until Good Friday. It's a deeply communal, sacred marathon. And it's not just a quiet reading, it's a major community event.
Right, there's food involved.
There's food and refreshment being served in the yard adjoining the chapel, with different community members defraying the costs. It's an intricate blend of solemn religious observance and communal solidarity.
And into this continuous sacred reading, between 11 p.m. and midnight on April 10th, 1933, absolute chaos arrives.
Chaos is right.
The defendants Procopio Reyes and 6 other men show up at the chapel, and they aren't carrying Bibles to join the reading, and they aren't bringing food for the yard.
What are they carrying?
They are carrying bolos, large machete-like knives, and crowbars.
Bolos and crowbars at midnight during a prayer reading. And what do they do with them? They don't attack the readers. They start constructing a barbed wire fence right in front of the chapel.
This is bizarre.
The chairman of the committee running the pobasa, Alfonso Castillo, rushes out and tries to stop them. He pleads with them, reminding them it's Holy Week, and pointing out that it is highly improper and deeply disrespectful to build a fence at that time of the evening during the sacred event.
But a verbal altercation breaks out.
Yep. The disruption is massive and immediate. The people inside the chapel and out in the yard panic.
I mean, naturally. Armed men building a fence at midnight.
The physical noise of construction, the armed men, the shouting, it shatters the sanctity of the event. Dishes and saucers are broken in the yard as people rush to flee. Benches are toppled over.
It's a total disaster.
The sacred pobasa, which is defined by its continuous unbroken reading, is entirely abandoned. It isn't resumed until the chief of police arrives to investigate the wreckage the next morning.
It is the complete, undeniable destruction of a religious event. So naturally, the men are arrested and charged. And the prosecutor charges them under the Revised Penal Code, specifically Article 133, which penalizes anyone who, in a place devoted to religious ceremony, shall perform acts notoriously offensive to the feelings of the faithful.
It seems like a slam dunk. They ruined Lent with crowbars.
But this is where the defense's argument reveals the underlying reality of the situation, and it forces the court to separate the sacred from the secular.
What did the defense say?
The men claimed they weren't there to protest the Catholic faith or mock the reading of the Passion of Christ. They claimed they were simply protecting private property rights.
Wait, property rights over the chapel?
Yes. The land the chapel sat on had been an informal donation from the Clemente family many years prior. A new chapel had recently been built, and there was an ongoing bitter dispute over whether this new chapel structure was encroaching on land that still legally belonged to the Clementes.
Ah, I see.
The defendants, Procopio Reyes and his crew, were partisans of the Clemente family. They were literally trying to physically draw a property line in the middle of the night.
I mean, the sources note they also tried to use a false alibi, claiming they weren't even there, which the court saw right through.
Right. They knew they were guilty of something.
The court noted that the fence construction was obviously done late at night in a way specifically designed to vex and annoy the gathering. But the Supreme Court's final ruling is the twist here.
It really is.
Think about the facts. The men brought weapons, ruined a Holy Week gathering, caused a stampede that broke the dishes, and entirely stopped a sacred, continuous reading. But the Supreme Court acquitted them of Article 133, offending religious feelings.
Yeah. Instead, they found them guilty of Article 287, which is unjust vexation.
Unjust vexation.
The court's reasoning makes perfect sense when you look at the strict textual requirements of the law. Article 133 requires an act that is notoriously offensive to the feelings of the faithful.
Right.
Building a fence, even a highly annoying barbed wire fence at midnight during a prayer session, is not inherently a mockery of religious dogma. Digging a post hole is not an insult to the vida, pasión y muerte de Jesucristo.
No, I guess it isn't.
It was a completely secular, earthly property dispute that violently bled into a religious space.
Here's where it gets really interesting. Think about the incredible irony of this ruling. These men showed up like a raiding party, terrified the congregation, and literally shut down the holiest week of the year for this barrio.
Yeah.
But because their underlying motivation was anger about real estate and not anger about religion, the law says it's just unjust vexation, which is essentially the legal term for being an extreme nuisance.
Exactly.
It's like calling the cops because a hate group is attacking your church, and the cops show up and issue the attackers a noise complaint because they were yelling about property taxes instead of theology.
It feels counterintuitive, but it's the only way the law can remain objective.
I suppose that's true.
The court recognized that the act was highly inappropriate, intimidating, and deliberately annoying. They clearly built it at midnight to maximize the disruption to the people they were angry with. But the nature of the act was secular. The intent was to assert a physical property boundary, not to scoff at the Catholic faith. It profoundly vexed the people present, but it did not offend their religious feelings in the specific legal sense required by Article 133.
So the Reyes case proves a really vital point. Just because an act happens at a religious ceremony, and just because it completely ruins that ceremony, it doesn't automatically make it a religious offense under the law.
Right. Location isn't enough.
The act itself has to target the sacredness of the event, not just the physical location of it. The barbed wire was offensive to the community's peace, but not to their theology.
Exactly.
Which begs a massive, towering question. If building a barbed wire fence during Lent doesn't count as hurting a religious feeling, what does? Who exactly decides what hurts a religious feeling?
That is the pivotal question of this entire deep dive, and it is exactly what the Supreme Court was forced to answer 5 years later in the 1939 case of People v. Bays.
The Bays case.
Right. If Belcorta defined the necessity of intent, and Reyes separated the secular from the sacred, Bays tackles the sheer, messy subjectivity of religious offense head on.
Let's get into People versus Bays. The date is April 14th, 1937. The location is the municipality of Lumban, province of Laguna.
Okay.
We have a funeral taking place for a man named Antonio Macabigtas. But this isn't just any standard funeral for the town. The rites are being conducted under the specific religious sect known as the Church of Christ.
And the conflict erupts entirely over geography and deeply held religious boundaries.
What happens?
The accused in this case, Enrique Veloca and his associates, are routing the funeral procession through the town, and they make a deliberate choice.
A bad choice, I'm assuming.
They force the procession to pass directly through the churchyard that fronts the local Roman Catholic Church. This churchyard belongs exclusively to the Catholic Church and is devoted to their religious worship.
And they don't just happen to accidentally wander through the yard on their way to the cemetery.
No, not at all.
They do this over the explicit physical opposition of the Catholic parish priest, Jose M.A. Bays. The priest files a formal criminal complaint, swearing under oath that through force and threats of physical violence, he was compelled to step aside and allow the funeral of another rival sect to pass through his sacred churchyard.
That's a huge violation.
He calls it a grave profanation of the place and an open disregard of the religious feelings of the Catholics. He charges Viroca and his men under Article 133, the exact same law the fence builders avoided.
But before this case even gets to a full trial to determine the facts, there is a fascinating piece of procedural legal maneuvering.
Oh.
The local fiscal, which is the prosecutor representing the state, decides to file a motion to dismiss the case entirely.
Wait, why would the prosecutor try to throw out his own case? Was he just trying to avoid the administrative burden of a messy religious trial?
It's deeper than that. The fiscal was applying a very strict, almost mathematical legal logic. In a motion to dismiss, you are essentially arguing to the judge, even if everything the complainant says is true, it still doesn't equal a crime under the law.
Okay.
The fiscal looks at the core facts. All Villaroca did was carry a dead body belonging to another sect through a guard. The fiscal then quotes a prominent legal commentary by Justice Albert, which attempts to objectively define an Article 133 violation.
What did Justice Albert say?
According to Justice Albert, an act is notoriously offensive to religious feelings when a person ridicules or makes light of anything constituting a religious dogma, works or scoffs at anything devoted to religious ceremonies, plays with or damages or destroys any object of veneration by the faithful.
Ah, I see. The fiscal is treating Justice Albert's commentary like a checklist.
Exactly, a checklist.
He's saying, let's look at the facts. Carrying a casket isn't ridiculing Catholic dogma. Walking through a yard isn't scoffing at a Catholic ceremony. They didn't smash a statue or destroy an object of veneration. The prosecutor literally wrote in his motion, the mere act of causing the passage through the churchyard belonging to the church, of the funeral of one who in life belonged to the Church of Christ, neither offends nor ridicules the religious feelings of those who belong to the Roman Catholic Church.
Yes.
He is essentially telling Priest Bays, I know you were angry, and maybe they trespassed, But objectively speaking, carrying a dead body is not a theological insult.
And the local court judge completely agreed with the prosecutor's secular objective logic and dismissed the case.
But the priest didn't let it go.
No, Priest Bays refused to let the state tell him what offended his faith. He appealed the dismissal, and the Supreme Court took up the case.
And what did the Supreme Court do?
The Supreme Court delivered a massive rebuke to the fiscal on two distinct fronts. First, on a procedural level, and this is vital to understanding how the justice system operates, the court explained how a motion to dismiss actually works.
Okay, lay it on me.
When a defendant or a fiscal files a motion to dismiss based on the argument that the facts don't constitute a crime, they legally must admit the facts as alleged in the complaint.
So they can't say, well, maybe it wasn't a churchyard, or maybe they didn't use force.
Correct. The fiscal cannot selectively deny the uncomfortable facts. Priest Bays alleged under oath that the yard was devoted to religious worship and that force and intimidation were used to push the procession through.
So the fiscal has to accept that.
The fiscal has to assume those facts are 100% true for the sake of the motion. And if you assume it's true that a rival sect used violence to profane a designated sacred space, you cannot simply dismiss it out of hand before a trial.
But the procedural smackdown isn't even the most important part of this ruling, is it?
Not at all.
The real bombshell, the part of this 1939 ruling that still echoes in legal commentaries today, is how the Supreme Court addressed the fiscal's arrogant claim that passing a funeral procession through a yard simply isn't offensive.
Yeah, this is the big one.
The court didn't bother looking at Justice Albert's objective checklist. They looked directly at the priest.
The Supreme Court completely inverted the fiscal's logic. They declared in a landmark statement that whether or not the act complained of is offensive to the religious feelings of the Catholics must be judged only according to the feelings of the Catholics and not those of other faithful ones.
Wow.
The court explicitly acknowledged a fundamental truth of religion. An act might deeply, profoundly offend the sincere feelings of those who profess one religion while being completely innocuous or even routine to those professing another faith.
Okay, stop right there. I really need to push back on this because this sounds like a legal disaster waiting to happen.
Okay, how so?
The Supreme Court is saying the prosecutor, who represents the neutral, secular state, doesn't get to use objective logic to decide what is offensive to a Catholic. Only a Catholic gets to decide what is offensive to a Catholic. Isn't that a blank check?
How do you mean?
Think about it. If the offense is judged purely by the subjective feelings of the person offended, what stops extreme hypersensitivity from weaponizing the law?
Give me an example.
What is my highly specific fringe religion dictates that someone wearing the color purple in my churchyard is a deep, grave, unforgivable profanation of my sacred space? What if I am genuinely emotionally devastated by seeing a purple shirt?
Okay, I follow you.
Does the state have to arrest the person in the purple shirt because my entirely subjective feelings were offended? How does the law prevent every single perceived slight from becoming a criminal trial?
That is the exact danger of pure, unchecked subjectivity. And it's precisely why the law maintains strict objective guardrails around this subjective core.
Okay, so there are guardrails.
Yes. If we connect this to the bigger picture, the court is doing something extraordinarily delicate here. They are creating a subjective standard, but embedding it deep inside an objective legal fortress.
Meaning what?
Yes, the nature of the offense, whether it hurts the soul, is judged entirely from the believer's viewpoint. The state defers to the priest on theology. However, the act itself must still meet the objective threshold of being notoriously offensive.
Define notoriously offensive.
It means it cannot just be mildly irritating or an accidental breach of etiquette. It must be a flagrant, undeniable, deliberate affront. The intent to mock or profane must be obvious to any reasonable observer.
So just wearing purple doesn't cut it.
Right. Furthermore, the act must happen in a specific, legally protected location, a place devoted to religious worship, or during the active celebration of a religious ceremony.
So context matters.
Hugely. You cannot claim religious offense under this article if someone wears purple at the grocery store, or even on the public sidewalk outside your church. The specific context of the sacred space acts as the legal brake on total subjectivity.
Okay, that makes a lot more sense. It's a compromise.
It really is.
The state is saying, we will completely trust your definition of what hurts your faith. We won't debate your dogma. But you only get to enforce that definition using our police power inside your legally designated sacred spaces or doing your specific ceremonies, and only if the insult is deliberate and severe.
Beautifully summarized.
It's a balance between protecting the invisible soul and maintaining public order in a diverse society.
Exactly. The law builds a wall around the church, says your rules apply in here, but demands undeniable proof when those rules are broken.
That's fascinating.
And this ongoing tension between subjective religious feelings and objective legal elements brings us perfectly to the actual text of the Revised Penal Code as we understand it from the commentaries provided in our source material.
Let's lay out the modern ground rules.
Let's look at how all these historical battles over intent, location, and subjectivity crystallized into modern ground rules. Let's examine Articles 132 and 133 side by side.
Let's do it. So we have two main tools the law uses to protect religion. Let's start with Article 132, which is titled Interruption of Religious Worship.
Okay, what are the elements?
According to the commentary, this article has very strict, very specific elements. First, and most importantly, the offender must be a public officer or employee.
Public officers.
Second, religious ceremonies or manifestations must be about to take place or be going on. And third, the officer physically prevents or disturbs them.
Notice the specific targeting of the offender here. Article 132 doesn't apply to a random citizen.
Right.
It is a direct descendant of the historical fears of state-sponsored religious oppression that we talked about under the Spanish regime. It is specifically designed to penalize agents of the government, police officers, mayors, soldiers who abuse their secular power to stop people from worshiping.
And the law takes this abuse of power so seriously that there's a qualifying circumstance. If the public officer commits this crime with violence or threats, the penalty increases significantly.
So if I'm a mayor and I send the police to padlock a mosque right before Friday prayers because I don't like their religion, I am getting hit with Article 132.
It is the citizen's shield against the state.
Exactly.
But then we have Article 133, offending the religious feelings. This is the article we've been circling around with the fence builders and the funeral procession. The elements here are totally different.
Walk us through them.
First, it applies to anyone, public officer or private citizen. Second, it requires acts that are notoriously offensive to the feelings of the faithful. And third, those acts must be performed either in a place devoted to religious worship or are during the celebration of a religious ceremony.
And the commentaries provided in our sources don't just leave us with the dry text. They give us a rapid-fire list of actual case examples that perfectly illustrate how courts apply these incredibly nuanced rules when messy, real-world conflicts happen.
Let's run through some of these cases because they are wild and they really test the boundaries of what we've been talking about. First, the commentary highlights the distinction between a meeting and a ceremony. It cites a case where people were reading the Bible and then they started attacking the dogma of certain churches while standing in a public plaza.
Okay, a public plaza.
The court ruled that this is not a ceremony or manifestation of religion under the protection of Article 132. It is merely a meeting of a religious sect under Article 131, which deals with peaceful assemblies.
The location and the nature of the act are paramount here. A public plaza is not a sanctuary. You don't get the highest level of religious protection if you're just holding a theological debate or a rally in a public park.
Right.
Contrast that public plaza with the Belcorta case we discussed earlier, which is also heavily cited in the same commentary. Reading verses from the Bible inside a private house is legally recognized as a religious service.
Because of the intimacy.
The intimacy, the intention, and the private setting define it as sacred, whereas yelling in a park does not.
Then there is the issue of threats. The commentary cites a case called People versus Mexica. In this scenario, a priest is standing at the altar, about to say Mass, and the offender walks up and makes an actual credible death threat on his life if he persists with the ceremony.
Wow.
The court found this is a clear-cut violation. It is the ultimate, notoriously offensive act, using the threat of lethal violence to profane the altar and prevent a religious ceremony.
But then the commentary takes us back to the incredible complexities of shared spaces, echoing the geographical warfare we saw in the Bayes churchyard case.
Oh, this one is interesting.
It mentions People versus Tengson. In this conflict, individuals performed burial rites in accordance with the specific rules and practices of a sect called Christ is the Answer.
Okay, Christ is the answer.
The problem: they performed these rites inside a Roman Catholic cemetery. The local Roman Catholic priest was, predictably, deeply offended.
Understand?
Interestingly, the commentary groups this with cases defining what is not legally offensive to religious feelings, though it explicitly notes we must compare it with the ruling in Bayes.
It really shows how legally tricky cemeteries are. You have multiple different faiths with entirely different views on the afterlife and sacred ground, all forced to share the ultimate permanent real estate.
It's a recipe for conflict.
How does a judge decide whose feelings get priority when the ground is literally shared? And then, to cap it all off, there's my favorite example from the commentary, purely for the utter chaos of it.
The Nanoi case.
It's the case of People versus Nanoi. An accused person, who is heavily intoxicated, attempts to grab the song leader of a religious sect during a gathering.
Just completely drunk.
The song leader panics and runs away, followed by the rest of the choir and then the other members of the sect, resulting in the total chaotic discontinuance of the religious services.
It sounds almost comical, a drunken disruption, but legally it's a profound test of the entire system we've just spent an hour breaking down.
How so?
Remember the late-night fence builders in Reyes? The court applies the exact same underlying logic to the drunk man in Nanoi. The intoxicated man grabbing the song leader wasn't making a calculated theological attack on their specific dogma.
Right. He was just drunk.
He wasn't trying to coerce them into another faith like they feared in Belcorta. He was just drunk, unruly, and out of control. Therefore, the court held him guilty of unjust vexation under Article 287, not a crime against religious worship.
So, synthesizing all of this, the law has essentially drawn two distinct, non-overlapping circles of protection around the concept of faith.
Let's hear them.
Article 132 protects the physical act of gathering from being squashed by the overwhelming power of government or public officers.
That's Circle 1.
And Circle 2 is Article 133, which protects the emotional and spiritual sanctity of the sacred space from being deliberately mocked, profaned, or insulted by anyone. It's the difference between a corrupt police officer chaining your church doors shut to silence you and a hateful neighbor walking into the sanctuary during prayer to intentionally smash a venerated stained glass window just to hurt your feelings.
And if you look at the common thread that runs through this entire historical stack of sources, from Belcorta in 1913, through the fence builders of Reyes, through the subjective standard of Bayes, all the way through these modern commentaries, it all boils down to one specific non-negotiable requirement.
Which is?
Deliberate intent. The commentary explicitly cites People versus Gasulga, noting that to be convicted, there must be a proven, deliberate intent to hurt feelings of the faithful.
So intent is everything.
The law isn't there to punish clumsiness, bad manners, real estate disputes, or mere drunkenness. It is there to specifically punish the act of weaponizing someone's sacred space against them.
It is an incredibly delicate balancing act. The law has to be entirely constitutionally blind to which God you pray to, thanks to the separation of church and state, while simultaneously being hypersensitive to how you feel when you do it.
We have certainly gone on quite a jurisprudential journey today. We've seen the evolution of a legal system actively and sometimes painfully trying to uphold the fragile promise of religious freedom in a complex, transitioning society.
We really have.
We started by looking at a man wielding a club in a Methodist living room in 1913, where the court demanded proof of his intolerant intent before applying the harshest penalties.
And then the pabasa.
Right. We moved to a late-night brawl with crowbars and barbed wire at a 1934 pabasa, where the court carefully distinguished a secular property dispute from a religious mockery, even when the disruption was absolute.
And we ended up at a forced funeral procession through a Catholic churchyard in 1939, where the Supreme Court dropped a philosophical bomb and made the groundbreaking decision that what is sacred and what is offensive can only be defined by the believer themselves, not the secular state.
Ultimately, these historical sources reveal that the courts are attempting an incredibly complex, perhaps impossible task.
Definitely impossible.
They aren't just looking at the physical damage of a broken dish, a ruined song, or a displaced funeral. They're attempting to measure the invisible intent of the disruptor and weigh it against the subjective emotional injury of the faithful. It requires immense nuance, deep context, and a profound respect for the boundaries of human conscience.
So next time you turn on the news and see a protest at a religious site or read about a disruption at a local place of worship, you'll know that the legal gears turning behind the scenes are far more complicated than a simple trespassing charge or noise complaint.
Much more complicated.
You'll understand the invisible historical lines the law is trying to draw between intent, context, and subjective faith. But as we wrap up this deep dive, I want to leave you with one final thought to mull over. So what does this all mean for the future?
It means the law will always be one step behind, constantly chasing the messy, evolving reality of human belief.
And it leaves us with this provocative question. If the legal offense is judged purely from the viewpoint of the faithful, as the 1939 Bees case firmly established. What happens when two different faiths share the exact same physical space?
That's the million-dollar question.
Right. What happens when the core, sincere religious practice of one group is inherently, unavoidably, notoriously offensive to the deeply held theological feelings of the other?
In a world that is only getting more crowded.
In a world that is only getting more crowded, more diverse, and more interconnected, how does a secular legal system referee a collision where both sides are legitimately the offended complainant? It's something to chew on. Thank you for bringing such a deeply engaging stack of sources to the deep dive today. We will catch you next time.
Welcome to the debate. Usually when we talk about legal boundaries, we rely on, well, the cold, objective precision of a surveyor. You know, you look at a map, you draw a line in the dirt, and trespassing is incredibly easy to define.
Right. It's quantifiable, it's visible. You are either standing on the property or you are off it.
It is absolutely measurable, but what happens in that boundary line doesn't just enclose a piece of real estate. What happens when it encloses a sacred space?
Yeah, that changes things entirely.
Exactly. Suddenly, that surveyor's tool is entirely useless. We are no longer just looking at a property line. We are trying to measure the boundary of the divine and, the impact of an intrusion on the human soul.
Which is the ultimate legal gray area, really. Because the law demands objective, verifiable proof, but religious experience is, by its very definition, internal. It's unseen.
It's the paradox of a secular state trying to use objective laws to measure the boundaries of the human soul. And that is the complex legal territory we are exploring today. The line between an ordinary public disturbance and a localized crime against religious worship. We're looking specifically at the jurisprudence surrounding the Philippine Revised Penal Code, particularly Articles 132 and 133, and their historical predecessors.
It's a brilliant lens for this, actually, particularly when you look at how these specific codes evolved following the official separation of church and state in the Philippines. It forces the question of how a neutral government acts as a referee for deeply non-neutral beliefs.
Right. So the central disagreement we are exploring is this. In the eyes of the law, should offending religious feelings be judged by a subjective standard, meaning it's based entirely on the sensibilities and specific tenets of the congregation that was disrupted? Or does it require an objective standard, meaning the state needs to see explicit doctrinal mockery and a clear intent to coerce belief?
And we're taking firm sides on this.
We are. I will argue that the legal standard must be subjective and defer to the specific believer's point of view, because religious offense is inherently experiential.
And I will argue for an objective standard, because, well, without requiring clear coercive intent or the explicit ridicule of dogma, the law risks being weaponized, allowing ordinary civil disputes to be dressed up as crimes against religion.
Let's get right into the foundation of this. If you want to see why a subjective standard is the only way this law actually functions, you just have to look at the 1939 Supreme Court ruling of People versus Bays.
Ah, yes, Bays.
The facts of this case are incredibly striking. You have a funeral for a member of a sect known as the Church of Christ, and against the explicit vocal objections of the local parish priest, this funeral was forced, literally using threats of physical violence, to pass directly through the churchyard fronting the Roman Catholic Church in Lumban, Laguna.
A highly charged situation, no doubt.
Highly charged, and a clear violation. The Supreme Court correctly recognized that whether an act is notoriously offensive to the feelings of the faithful, as written in Article 133, well, it must be judged exclusively from the complainant's viewpoint.
Exclusively?
Yes, because religious devotion isn't universal. It is entirely unique to each sect. A universal or, secular standard simply cannot accurately measure the profanation of a sacred space. What deeply offends a Catholic might mean absolutely nothing to a Buddhist. The law correctly protects the deeply held subjective sanctity maintained by the specific worshipers whose space was violated.
See, I look at that exact same mandate and I see a massive legal trap.
How so?
Because relying on subjective feelings makes the law dangerously broad. I know what people listening are probably thinking right now. If we make it subjective, couldn't anyone just claim their religion was horribly offended to get their neighbor arrested?
Well, that's a bit of a stretch.
But they would be right to ask that. I look at two crucial cases for this: People versus Reyes from 1934 and U.S. versus Balcorda from 1913.
Let's start with Reyes then.
Right. Reyes perfectly illustrates why subjectivity is so dangerous. You had men carrying bolos.
Heavy machetes, essentially.
Yes, machetes and crowbars. They show up late at night to build a barbed wire fence right in front of a chapel. And this wasn't just any night. This was during a sacred Lenten pabasa, which is a deeply revered tradition involving the continuous chanting of the Passion of Christ.
So a highly sacred moment.
Exactly. And the terrified congregation fled in such a massive panic that benches were toppled over, dishes were smashed. It was chaotic. Yet the court rightly downgraded the charge from a severe crime against religious feelings to unjust vexation, which is essentially a catch-all misdemeanor for annoying or distressing someone.
And you think that downgrade was justice?
I think it was legally precise. True religious crimes require an objective attack on dogma or an intent to coerce someone's conscience. If we don't demand that objective threshold, any frightened or offended congregation could elevate a basic nuisance or property dispute into a severe crime against religion.
Okay, you are holding Reyes up as the ultimate triumph of objective reasoning, but that completely ignores the reality of what happened. I mean, Reyes was fundamentally a land dispute trying to masquerade as a religious disturbance.
How so? They interrupted a pabasa with heavy machetes.
But why were they there? The attackers were partisan of the Clemente family. Years prior, that family had informally donated the land for the chapel, and now they were claiming the new chapel impinged on their remaining property.
Okay, but
It was an agrarian conflict. It was a civil property line dispute. In stark contrast, the bias case involved a direct violation of a dedicated religious space by a rival sect pushing a corpse through a sanctuary. The core friction here is this: how can a secular judge genuinely objectively decide what profanes a sacred space without deferring to the subjective believers who actually hold it sacred?
well, mechanically speaking, how does a judge measure that subjective feeling? Does he put the congregation on the stand and measure their tears?
Oh, come on.
No, seriously. You are handing the penal power of the state over to the internal, unverified emotions of an individual.
It's not about measuring tears, and it's not about random unverified emotion. It's about looking at the established tenets of that specific faith. A judge doesn't have to feel the offense. The judge just has to verify that the believers, based on their doctrine, genuinely feel the offense.
But let's look at what the prosecutor, the provincial fiscal, actually did in the Bicius case. The fiscal initially filed a motion to dismiss the complaint entirely, relying heavily on the legal commentary of Justice Albert.
Right, which was overturned.
Yes, but Justice Albert was very clear. An act is notoriously offensive only when a person explicitly ridicules dogma, scoffs at ceremonies, or literally destroys an object of veneration. Think about it objectively. Merely moving a corpse through a yard does not objectively mock Catholic dogma. It doesn't smash an altar. It doesn't scoff at the Eucharist.
But
The fiscal recognized that the act of moving a body belonging to another sect doesn't inherently ridicule the Roman Catholic Church.
the fiscal in Banyes was wrong, which is exactly why Justice Conception and the Supreme Court completely reversed that dismissal. The fiscal omitted the most crucial fact. The churchyard belonged to the church and was formally devoted to its religious worship.
I still don't see how that overrides the lack of objective mockery.
Because Justice Conception explicitly ruled that whether an act is offensive is a question of fact that must be judged only according to the feelings of the Catholics and not those of other faiths.
Which makes the law entirely unpredictable.
No, it makes the law appropriately tailored. You cannot impose a rigid, objective checklist-like, requiring the physical destruction of a venerated object when the offense being alleged is the spiritual pollution of the space itself.
Spiritual pollution is awfully hard to legislate.
Think of it like this. Your objective standard treats the law like a bouncer at a nightclub. The bouncer only cares if you broke the explicit rules. Did you punch someone? Did you smash a glass? Yes or no? But a subjective standard treats the law more like an anthropologist. It asks, what does this space mean to this specific community? And how did this intrusion violate that specific sacred meaning?
But a criminal court is not an anthropology department. How is a citizen supposed to conform their behavior to the law if the threshold for criminality is locked entirely inside the mind of the local priest?
It's not just locked in their mind.
If the bouncer doesn't have clear rules, anyone can be thrown out for any reason. But you're also entirely ignoring the mind of the person committing the act. We can't just talk about the effect on the believers. We have to talk about the intent of the intruder. Which brings us to U.S. versus Balcorda.
The 1913 case with the Methodist Episcopal Service.
Exactly. In Balcorda, a man entered a private house completely uninvited. You had between 10 and 20 people holding a Methodist Episcopal service. The man threatens the congregation with a club and completely shatters the divine service.
It was a violent intrusion.
Now, based on everything you've just argued about subjective terror and interrupted worship, this should be the ultimate crime against religion, right?
It certainly disrupted their communion with the divine, yes.
Yet the Supreme Court ruled it was merely a misdemeanor against public order under Article 571 of the old Code, rather than a severe crime against religious worship under Article 223. Why? Because there was absolutely no proven intent to coercively control the religious beliefs of the worshipers.
And you honestly believe a man threatening a prayer service with a club is just a generic public disturbance?
I believe we have to look at the historical mechanism of the law to understand why the court ruled that way. Go back to the Spanish constitutions of 1869 and 1876. Under Spain, there was a strict state religion. The Catholic Church was part of the state apparatus.
Right, yes.
Other faiths were tolerated, but only in private, and only as long as they didn't violate Christian morals.
Right, it was a completely uneven playing field.
Entirely. But when sovereignty changed and the American influence Philippine Bill of 1902 was enacted, it caused the complete and total separation of church and state. Suddenly, the state is no longer the enforcer for Catholic dogma.
Okay, but how does that excuse the guy with the club?
So how do you write a penal code that protects religion without favoring one? The legal evolution proves that the new law targets the tampering of conscience. To commit a crime against religion, you must have the specific, targeted intent to force someone to perform an act of worship or prevent them from doing so out of religious intolerance.
So the motive is everything?
Yes. In Balcorda, the attacker didn't make any theological comments. He didn't demand they renounce their faith. He just threatened them with a stick. Without that coercive, anti-religious intent, it is legally just a public disturbance.
I completely reject that framework because it creates an impossibly high bar that leaves worshipers utterly unprotected from traumatic disruptions. You're saying a congregation has to basically interrogate a man waving a club at them to find out his theological motivations before the state will truly protect their sacred rights.
Well, no, not interrogate, but the state has to prove intent.
Let me offer an analogy. If someone burns down a public library, the loss of knowledge, the destruction of the archives, and the devastating deprivation to the community is exactly the same whether the arsonist explicitly hated books and literacy, or whether they just wanted to clear the land for a parking lot. Shouldn't the actual devastating disruption of the divine service be enough for the law to step in?
Your arson analogy actually proves my point for me, though.
Does it?
Yeah. Arson is a crime against property. If I burn down a library, I am punished severely for destroying the building and creating a public hazard, regardless of my feelings about literacy. I am punished for the objective act. But a crime against religious worship is a crime against a constitutional right. You are arguing for a special category of crime based purely on the emotional state of the victims.
Not just their emotional state, the reality of the harm. In Balcorda, a congregation was terrified in their own private space by a man with a weapon. The religious practice was violently stopped. You are arguing that because the attacker didn't explicitly shout a theological objection, the state should just hand him a misdemeanor ticket for being a public nuisance.
It's the precise application of the law.
But that ignores the reality of what it means to worship. Why must we prove the attacker's inner theological motivation before we acknowledge the congregation's right to worship in peace was violated?
Because if we punish the effect rather than the intent, the distinction between a crime against public order and a crime against religion completely collapses. The attacker in Balcorda didn't get away with it. He was sentenced to imprisonment and a fine. But he was punished for disturbing the public order.
It still feels insufficient.
Look at the real-world implications of what you're suggesting. If a drunk person wanders into a university lecture hall and starts yelling, it's a misdemeanor. If that exact same drunk person wanders into a church and starts yelling, you want to charge them with a highly specialized, severe crime against religious feelings. If you elevate every disturbance that happens to affect a religious gathering into a specialized crime, you are essentially granting special elevated property rights to religious groups over secular groups.
But that assumes a church is exactly the same as a lecture hall, and the law explicitly recognizes it isn't. It is not about granting special property rights. It is about acknowledging the specific, heightened nature of a space intentionally devoted to the divine.
Which brings us right to the mechanism of physical place under the law.
Exactly. Let's look at the exact wording of Article 133. It penalizes acts notoriously offensive to the feelings of the faithful performed in a place devoted to religious worship. The physical boundaries are central to the crime.
I agree the statute mentions the place, but dirt is just dirt.
Not to the faithful. In Badius, the churchyard wasn't just a patch of grass. You can't separate the physical dirt from the devotion of the people standing on it. The physical boundaries of that yard acted as a container for their sacred rites.
Okay, but
when the rival sect forced their funeral through that yard, the intrusion was inherently offensive because of the religious nature of the physical place. The space is the sanctuary. The law recognizes that violating that specific space is the offense.
I will concede that the location is a required element under the statute, but I completely reject the idea that crossing a physical boundary magically transforms any offensive act into a religious crime. We have to return to Reyes to see why.
Okay, back to the machetes.
Let's look at the context of the physical space in that case. The pabasa happens during Holy Week, continuing day and night without interruption from Palm Sunday to Good Friday. It is the holiest time of the year. The defendants arrived late at night, armed, and built a fence right in front of the chapel, interrupting the reading of the life and death of Christ.
Right in the adjoining yard?
Yes. If physical place and subjective religious context were enough to trigger Article 133, Reyes would be the textbook slam dunk example.
But the court acquitted them of the religious crime.
Exactly. The court acquitted them of the Article 133 charge and convicted them only of unjust vexation. Despite the deeply sacred timing of Holy Week, despite the physical location being directly adjacent to the chapel, the objective reality of the situation was that it was an agrarian dispute.
A land grab.
Right. The Clemente family partisans were trying to mark a literal property line. The objective reality of the civil dispute overrode the intense, completely genuine emotional reaction of the faithful. No matter how sacred the location, the act itself building a fence was not objectively an attack on religious dogma.
But wait, your reading of Reyes completely flattens the nuanced difference in physical spaces between the two cases. It's not just a yard as a yard. In Reyes, the disturbance happened in the yard adjoining the chapel, where refreshments and food were being served to the people attending the pabasa. It was a communal gathering space outside the strict sanctuary.
It was still essential to the event, though.
True. But in Bayes, the funeral was forced through the specific churchyard fronting the Roman Catholic Church, a space historically, doctrinally, and canonically set apart for the exclusive rites of that specific faith. A secular judge might look at both and just see grass, but a subjective standard allows the court to understand that the feeling of profanation is inextricably tied to the specific doctrinal reality of the sanctuary. The state has to defer to the believers to understand where the secular world ends and the sacred begins. But a law cannot operate on a sliding scale of subjective sanctity. If a priest can simply point to a map and declare, "My feelings are notoriously offended because this specific patch of dirt was crossed," and the state accepts that without requiring any objective proof of religious mockery or coercive intent, we have entirely lost the rule of law. We are right back to the Spanish Penal Code.
How so?
Because the entire point of transitioning to the Revised Penal Code was to strip away the special privileges of a state-sponsored religion. Under the old Spanish regime, simply being Catholic gave your physical spaces elevated legal shields. The state enforced your sanctity.
Right. The new system leveled the field.
Yes. Now all faiths are equal under the law. Therefore, the legal standard must be objective. You must prove an act of explicit ridicule, like destroying an altar, or an intent to coerce conscience.
Otherwise, the state is just acting as the taxpayer-funded enforcer for whichever sect claims to be the most subjectively outraged.
I think this is where we hit the bedrock of our disagreement. To me, the concept of religious freedom is entirely hollow if the law refuses to protect the subjective sanctity of the faithful. As the Supreme Court validated in People v. Bays, true protection of religious worship requires the courts to do the hard work of viewing an offense through the eyes of the believers.
It's a dangerous precedent.
But a secular, objective checklist of what constitutes profanation will always fail because it attempts to apply cold surveyor's logic to the profoundly experiential nature of faith. When a sacred space is violently intruded upon, the primary harm isn't to a piece of property. It is a wound to the religious feelings of the congregation. If the law ignores that reality, it fails to protect the very thing Article 133 was written to defend.
And I maintain that a strict, objective standard is the only firewall we have against the weaponization of the law. As we've seen clearly in both People v. Reyes and U.S. v. Balcorda, human beings are incredibly adept at masking ordinary property disputes, civil conflicts, and public misdemeanors behind the impenetrable veil of religious outrage.
That is a cynical view, but fair.
By demanding explicit doctrinal mockery or clear coercive intent, the law protects true religious freedom. It ensures that the penal code cannot be hijacked by subjective grievances. Failing to look beyond the worshipper's outrage risks elevating ordinary nuisances into crimes against the state, which is a very dangerous path for any secular democracy.
Well, what is undeniably clear from both of our perspectives is that the evolution of these laws represents a fascinating, almost impossible historical balancing act, moving from the heavy hand of the Spanish Penal Code, which essentially merged church and state, to the Revised Penal Code under a modern framework of separation, forces the legal system into a very difficult position.
It truly does. It is the legal system desperately trying to figure out how to be a neutral referee in a realm entirely defined by deeply held non-neutral beliefs. And the source material holds even more nuance regarding how this historical context continues to shape legal interpretation today, especially as courts try to parse out exactly what intent looks like.
And it leaves us exactly where we started, looking at a boundary line. Only this time, it is left to you, the listener, to decide whether that line should be drawn by the objective, quantifiable tools of the state, or by deferring to the subjective faith of the believers whose sacred spaces hang in the balance. Thank you for joining us on the debate.